So a very good evening to all. I welcome all the participants to our legal literacy program. We, Multiple Action Research Group, is a New Delhi-based NGO working since 1985, pioneers on the legal empowerment of disadvantaged and marginalized groups through legal awareness, social legal research, advocacy initiatives, and legal aid. MARG works across the country on issues of marginalized communities, including women, children, Dalits, transgender persons, laborers, etc. For over 3 decades, MARG has spread knowledge of law among people and built their skills to effectively use the law to secure justice. So, in the series of our legal literacy program, we are back with a very interesting and burning topic, that is law against child sexual offences, age of consent, and marriage under the customary law, a legal dichotomy. The main aim of this legal literacy program is to highlight the contradiction between the law against child sexual offences, age of consent, marriage governed by the customary laws, and the implementation of POCSO in India. Through this session, we will also understand the impact of the POCSO Act on the juveniles who are entering in nuptial relationship, which includes customary practices. And for enlightening us on the said topic, we have a very dignified speaker with us, Mr. Rajesh K, Special Judge, Fast Track Special Court, POCSO Cases, Kozhikode. Sir is also designated as Sub-Judge, Secretary, District Legal Service Authority, Wayanad. Sir is also credited for writing the story of a very famous film, Incha, in Panya language, which was penned down to educate and to create awareness among the tribal communities about prohibition of child marriage and the provision of POCSO. As we all hearing in day-to-day news that many tribal peoples are getting charged under the POCSO Act for marrying under the aged girls in lieu of their age-old marriage custom. As such, this fully fledged feature film came out as a shield for creating law awareness amongst the tribes people. Sir, it's our privilege and honor to have you with us because no one else could tell us better on this topic other than you. We heartily welcome you and request you to please enlighten us with your experience and knowledge. Over to you, sir.
Thank you, Asta. I think I am audible to all of you. Am I audible, Asta?
Yes, sir.
Respected Director, MARG Organization, Madam Shima Mishra, my friend Noor Muhammad Alam, and the moderator Asta. A warm good evening to you all. Hope 25 members are joined in this online platform. Shall we wait for others to come or shall we start? Asta?
We can start, sir.
Yes, sir, we can start. The participants will come in between and join it.
Okay, thank you. The topic opted by MARG is having contemporary relevance in the social living of our country, India. The topic selected is child sexual offences, age of consent and marriage under customary law, a legal dichotomy. So the topic itself shows there is a legal dichotomy because of marriages under customary laws, which will verified in the ambits of child sexual offences. Let us consider this aspect in detail. Child sexual offences, as you all know, there is nothing particular as an offence against child sexual offence. Any sexual offence against a child come under the purview of child sexual offences. To classify it, we can briefly classify it as in three types: penetrative sexual assault, and sexual harassment against a child. Sometimes children are used for pornography also. So these types of offenses are there, which are punishable under the Indian Penal Code. Earlier. Now, after India being member of UN General Assembly, we have adopted the Convention on the Rights of Child, adopted by UN General Assembly on 11/12/1992. This convention prescribes certain set of standards to be followed by parties while dealing with child sexual abuse. On the light of this convention, we have enacted a new law in the country named as Protection of Children from Sexual Offences Act in the year 2012. In fact, we adopted the convention, UN General Assembly Convention on 1992, but we enacted the law in the year 2012 only. Now the topic become relevant. How an enactment can make socio-legal issues in the society. As the participants all well know, I think the participants are from different fields of society. There are child right activists, legal law students, advocates, police personnel, and other government institutionals attending this seminar. I told you about implementation of POCSO Act and certain impacts it's made in the society. Of course, obviously, it made a impact that the increasing child abuse become reduced by implementation of this act. The penal provisions are providing a long-term and rigorous punishment against sexual offenses against children. Because of that reason, the child abuse reduced to a certain extent, I may say reduced to a certain extent. Or on other aspect, child abuse has been increased in reporting. Earlier also we have cases of child abuse, but sometimes they might have been not reported due to various reasons, because of the social status, because of the future aspects of the child. By considering all these aspects, earlier it was not reported. But after the implementation of POCSO Act, the reporting of the cases stands increased. That's a positive impact of the implementation of the act in society. At the same time, there is a negative impact also for this act, particularly while considering the act with the customary rights of certain marginalized societies in our country. As you people know, our country is a multilingual, multicultural, multi-religious country living peacefully in our country. After getting independence, so many laws were enacted in our country to make our society civilized. As part of the same, I'm only concentrating the laws relating to marriage and sexual offenses. Sexual offenses I must say it is governed by Indian Penal Code, and regarding children, particularly POCSO Act was enacted in the year 2012. While going to the marriage laws, we have in Hindu Marriage Act in 1956, Special Marriage Act in the year 1954, Indian Christians Marriage Act in 1872, Muslim Law Shariat Application Act 1937, Anant Marriage Act in 1937, Parsi Marriage and Divorce Act in the year 1936, Foreign Marriage Act in the year 1969. All these laws deals with marriage of different religions living in a country. People having legal background might know that whenever there is no law to govern a particular field, we have approved customs, which is approved by law. Approved custom means it was approved by law. So whenever there is no custom, there is no law to govern a particular field, the law will first go behind the custom. What was the custom prevailed? What was the custom prevailed in that community or in the society in connection with that field? Thus, after attaining independence, all the laws were enacted to govern the particular customs or to legalize the particular customs prevailed in our country, and those customs were made as laws of the land. Thus, Hindu Marriage Act governs the marriage, divorce, succession, and everything of Hindus living in India. Indian Christian Marriage Act governs the marriage laws of Christians. Anant Marriage Act, Anant Karch marriage. Anybody from Punjab here? Anybody from Punjab? No. Anant Karch Marriage Act is the marriage laws of Sikhs. Parsi Marriage and Divorce Act governs the marriage and divorce laws of Parsis. Foreign Marriage Act. If a if a citizen of India wants to marry a foreigner, they can marry under the provisions of Foreign Marriage Act. Likewise, Muslim personal laws are there governing marriage, that is nikah. Quran was made applicable in India by the implementation of Muslim Personal Law Shariat Application Act 1937. By this act, Quran is applicable to the Muslims living in India. All these laws specifies certain age limit to get in marriage of parties. All these laws except Indian Christian Marriage Act and Muslim Personal Law says that the age limit for marriage for a male is 21 years and age limit for a girl is 18 years at the time of marriage. As per Parsi Marriage Act, Section 3, no marriage shall be valid if the male is not attained 21 years and female attained 18 years. Anant Karch Marriage Act regarding 6, Section 3. This act is not applicable to any marriage between persons not professing Sikh religion. And they also, it says that, and there also no age is specified in Anant Karch Marriage Act. Then dissolution of Muslim Marriage Act 1937. It's a particular act applicable to Muslim women only. For marriages of Muslims, versions of Quran is applicable. Under Dissolution of Muslim Marriage Act, it says particular act enacted for dissolution of marriage of Muslim women. Muslim women can seek dissolution of marriage. One of the ground is that she has not attained the age of 18 at the time of marriage. Likewise, we have Muslim Muslim marriages are governed by Quranic versions. Quran version 458 says that each and every individual who is genuinely, intellectually, and monetarily prepared to do so, has the commitment of going into marriage. That is the Quranic version says regarding marriage, and there is no age prescribed. As per Quranic version, parties who attain puberty, who is capable of, who is intellectually and monetarily capable of doing so, can commit into a marriage. So there is no age limit. Foreign Marriage Act also says age limit as 21 and 18 years, section 4C. Then all these customary laws was governed. Particular customs prevailed in certain communities in the country. Before independence, all these religions were practicing their customs for marriage and other civil rights. After independence, these laws were codified. Thus, we had Hindu Marriage Act in the year 1955. Hindu Marriage Act governs all the persons, that is section 2 says it applies to all Veerashaiva, Linkayat, followers of Brahmo, Prarthana and Arya Samaja. It is also applicable to Buddhist, Sikh, Jain, and it is applicable to who are not Muslims, Christians, Parsi or Jew. That means except Muslim, Christian, Parsi or Jew, all other persons are governed by Hindu Marriage Act after the implementation of Hindu Marriage Act in the year 1955. For Jews, they have their own act. For Muslims, Quran is there. For Christians, Indian Christians Marriage Act is there. For Parsis, Parsi Marriage and Divorce Act is there. So all persons are having particular marriage laws in our country. At this point of time, we made, after adopting the conventions in the UN General Assembly in the year 1992, India, being a part of UN Assembly, enacted POCSO Act, Protection of Children from Sexual Offences Act. Prior to that, we have Prohibition of Child Marriage Act. Earlier it was Child Marriage Prohibition, Child Marriage Restraint Act. Later it was amended as Prohibition of Child Marriage Act in the year 2006. In the year 2006, that is Child Marriage Prohibition Act is there much earlier. At that time also, the age of marriage for a male is fixed to 21 and female is fixed to 18. So marriage of an Indian citizen below the age of 21 for male and below the age of 18 for a female was made as unlawful, offense under the Prohibition of Child Marriage Act. Even then, as we all know, practically child marriages were happening in our country. Sometimes it may come into book or sometimes it may not. depends upon the society where the couples live and the nature of social setup prevailing in that particular area. But after implementation of POCSO Act, the scenario has changed, particularly in the case of tribes in India. Now we are going to the next part of the topic selected today: marriage under customary laws. I'm not going for consent, age of consent and marriage under customary law. Consent is different. Consent we can discuss on a different angle. Let me take marriage under customary law as a particular point in this seminar. All we know that 38% of our population in our country are tribal people. We have bills in Maharashtra, Chhattisgarh, Gujarat, Rajasthan, and Tripura. We have Gonds in Andhra Pradesh, Telangana, Madhya Pradesh, Bihar, and Orissa. We have Santals, we have Mundas, we have Kashis, Gauros, Angamis, Bhutias, and Chanjus. All these different tribal communities together form 38% of our population in India. The question is, under which religion they belongs? If they belongs to Buddhist, they have laws. If they belongs to Sikhs, they have marriage laws. If they belongs to Jainas, if they belongs to Vairashaivas, Linkayat, Brahmos, they have laws. If they have Parsis or Jews, they have laws. But what is the important aspect to be noted? That all these laws says that this enactment, all these laws means Parsi Marriage Act, Anant Marriage Act, Muslim Marriage Act, Christian Marriage Act, etc. Says all those enactments are applicable only to those persons who profess Christianity, Parsism, Sikhism, or Jainism, etc. So these tribes which I mentioned are not belongs to these religions. Then we have only one enactment remaining, that is Hindu Marriage Act. In section 2 of Hindu Marriage Act, it is specifically stated that it applies to all persons who belongs to Veerashaiva, Linkayat, Brahmo, Prarthana, Arya Samaja, Buddhist, Sikh, Jaina, Buddhist, Sikh, and Jaina. And it has made an exclusion under section 2C that this act is not applicable to Muslim, Parsi, and Jew. In this also, tribes are not covered. Then which law governs the marriage rituals of tribes who score 38% in our population? That question posed this topic. That question inspired MARG to adopt this topic today for the seminar. Tribes under Constitution, we have a schedule itself who are the tribes in India. But regarding the laws governing their marriage, what is the law applicable? As of now, no laws are enacted to govern the field of marriage of tribes in India. Tribes in the sense different sects of tribes. As I said, Bhils, Gonds, Santals, Mundas, nobody has any specified law governing their marriage. Then how they get married? Under what laws they get married? At this point of time, we have to discuss about law for a short as a short subject. whenever there is no law governing a political field, then the constitution says the court has to go and look into the customs. Customs means uninterrupted, continuously followed custom prevailing in that field. If that be so, we all know that tribes are getting married, they are begetting children, their followers, successors, next generations are there. We are now seeing mostly the fifth generation tribes in our country. At that time, you have to go to the custom. And whether there is any uniform or codified custom prevailing in our country which governs the marriages of tribes. No. No, there is no uniform or no codified custom prevailing in our country governing the field of marriage in our country. So what to do? We have to go to each and every particular tribal sect and their customs to decide the validity of a marriage. What is the important aspect is that scheduled caste and scheduled tribe pupils are not made a beneficiary or applicable party in Hindu marriage. So they cannot go to court on the strength of a particular enactment for getting divorce or getting maintenance or establishing their civil rights with respect to or disputes with respect to their marriage. They have no laws. So what they do, they continue to follow their customs prevail in their community. And these customs are varying from place to place, state to state, district to district, even different sects in the same district. That is varying. We cannot have a uniform or codified custom for the marriage of tribes in our country. What is the impact of this dilemma while we discussing the provisions of the POCSO Act? So for marriage, we have so many laws, and for those who are no laws, we can follow the Special Marriage Act. There also age is specified as 21 and 18. Since customary marriage is approved for tribal community, they are legally entitled to follow their customs for marriage. To my knowledge, as far as my studies are concerned, the custom prevailing in all the tribal sects in India is that whenever the boy gets physical maturity, physical fitness to look after a family, he can go and get in marriage. Whenever a girl attains puberty, she is fit to be a party to the marriage. That is what is same Quran says, Muslim law says. So if their custom is approved under law for marriage, they can marry at the age of attaining puberty for a girl and puberty for boy. But in tribal community, they in certain countries, to my state, I would say that in Kerala, they says that whenever the boy attains the physical fitness to look after a family, that means to bring a bunch of fire stick, and he is able to bear a headload of sack of paddy. He is physically fit to maintain a family. That is what is their concept. So they can go to solemnize a marriage. The dichotomy The legal dichotomy comes at this stage. Under custom, a tribe is allowed to enter into a marriage before he attains the age of majority as provided under the Prohibition of Child Marriage Act. So his marriage is valid as per the custom. So sometimes he may get into marriage at the age of 16. Girl may be at the age of 14 or even 13. Once she attains puberty, she can be a party to a marriage. After getting marriage, as per their social system, they start living as husband and wife. Of course, there may be, or sometimes always, the wife will become pregnant in the wedlock. Usually, they don't need any medical aid or medical assistance for their delivery in our tribal community. They are intellectually they have high technologies for doing for taking delivery, etc. Even a tribal friend of mine says that his mother was under certain complications with respect to delivery while he was born. At the time, the maid who took delivery of that lady went and asked the Mupan, the head of the tribal community, whether the mother has to be saved or child has to be saved. If both these has to be saved, she shall not be conceived further. Then the Mupan advised her, save both child and the mother, and she will not be pregnant hereafter. Thus, that maid who took delivery of that boy, that person, conducted tubectomy, and thereafter that lady never became pregnant. So they are having that much of knowledge with them. But in the present scenario, we the civilized people go to their hamlets. Once the ASHA worker or medical official, medical department official came to know that one of the tribe was pregnant, she will go to the hamlet and repeatedly persisting her to come to the hospital, So as part of these activities, mostly at the 10th month or advanced pregnancy stage, the tribal girl will come to hospital for treatment or delivery, not for treatment, for delivery. At that time, our technology is so advanced, our medical field is so advanced. The doctor comes to know that this particular girl is not attained the age of 18. Then starts the problem. Then comes the provisions, the stringent provisions of POCSO Act into play. Under POCSO Act also, a child is defined. Section 2C of the POCSO Act defines a child is a person below the age of 16, below the age of 18. So whoever below the age of 18 is a child under the provisions of POCSO Act. So a girl below the age of 18 become pregnant means she was sexually assaulted. If a sexual assault come into the knowledge of a person, he is bound to report this fact to the authorities under section 19 of the POCSO Act. Under section 19 of the POCSO Act. If he failed to report the same to the authorities, he will be punishable under section 21 of the POCSO Act. So what the doctor will do, in order to save or in order to comply his statutory duties, he will report the same to this special juvenile police unit or the police concerned. When police came to know about this incident, they are bound to register a case under section 154 of CRPC. So once this girl goes to the hospital for delivery and the doctor knows that she is under the age of 18, then definitely there will be a criminal case registered against the husband, a innocent husband who has been looking after his family all throughout. At the time of delivery, they will become separated by the provisions of law, by booking him under the provisions of POCSO Act. As you know, punishment for penetrative sexual assault under the provisions of POCSO Act is not less than 10 years under section 4. If it is aggravated, not less than 20 years, or it may go up to life. That means all the provisions, all these penetrative assaults and sexual assaults are non-bailable offences under the eye of law. When this matter come to the court, now court is the forum where the laws are interpreted. Customs are verified. Validity of the customs are appraised, analyzed. The girl comes to the court. The boy comes to the court. Family members, parents of both bride and groom comes to the court, says that these people are legally wedded as per our custom and they have not committed any offense. Whether the court can give approval to that custom? There is no codified custom. There is no approved custom among the tribes or approved by legal system in this country. So by considering the provisions of POCSO Act, this groom will be sent to jail. And more pathetic situation is that once a person booked under an offense, he will get bail on his executing a bond with sureties. What is the condition of these tribal people in our country? They don't have their own land. They don't have their own investments. They don't have their own savings. They cannot give solvency. So the person who sent to jail will not get bail till the culmination of the trial and till the end of the trial. And what will be the end of the trial? Section 29 and 30 of POCSO Act says, reverse burden. As per criminal law in our country, the prosecution has to prove the guilt of the accused beyond all reasonable doubts. But in the case of POCSO Act, Section 29 and 30 says, once the fundamental facts are proved by the prosecution, then the burden shifts upon the accused to prove that he has not committed the offense. And it is a very difficult and Herculean task to prove that I have not committed the offense. One can say that I didn't commit any offense. Then the prosecution comes with their evidence. They saw the culprit with the girl last night. They saw the culprit living with the girl for the last 1 year. Those all evidence prosecution can bring. But in the case of accused, he has to prove that I didn't live with the girl. I didn't consume with the girl. I didn't had customary marriage with the girl. All these negative evidence, it is very difficult to prove before the court. So ultimately, the case will end up with conviction. A regular practice, courts have certain discretions while imposing sentence. Indian Penal Code says most of the cases the punishment will be up to 5 years, 3 years, 10 years, 7 years, etc. That means court has the discretion to give from 1 day imprisonment to 10 years imprisonment. Under the POCSO Act, this discretion given to the court has been fettered. Now the court has no such discretion. Once the court finds that the accused committed the offense, when he found to be guilty, then the provision says that he will be sentenced not less than 10 years in the case of a penetrative assault. Penetrative assault which made the girl pregnant. For aggravated offense, it is not less than 20 years. So by considering the fact that these people are customarily married, what the court will do, court will give the minimum punishment prescribed under that, which is 10 years. So that is the dichotomy which mentioned in the topic today. Law gives approval for the customary marriage of the tribes. After giving that approval, we cannot say that you shall not be conceived. You shall not begot your future generations. That is their civil right. When they become pregnant and conceived, then we will go with another weapon. You are a criminal. You are an offender under the provisions of POCSO Act. You see another dichotomy. Child Marriage Prohibition Act came in the year, that was amended in the year 2006. I think it was earlier 1934. I didn't remember the year. From that year onwards, child marriages were prohibited. As per a study in our country, less than 2% of child marriages were reported throughout our country. That I initially stated. Such marriages were reported by considering the social status, social living conditions of the particular community from where the spouses, bride and groom comes. Mostly those cases are not reporting. Even the provisions of Prohibition of Child Marriage Act was not that much effectively implemented by the different governments across our country. So there were no such cases which provoked us to make such a seminar regarding Child Prohibition Act. But when POCSO Act came, the scenario has changed. It has provided a clause, punishment for non-reporting. Whenever a person came to know about this offense, he is legally bound to report to the authority concerned. Otherwise, he will be punished for 6 months and fine. That provision made a lot of changes. When the bride comes, a pregnant wife comes to the hospital or medical authorities, and they came to know that this girl is below the age of 18, they are legally bound to report the same to the authorities concerned, that is police or special juvenile police. Then we say that though you are married legally or customarily, the pregnancy begotten out of the sexual act committed by the husband become an offense under the provisions of POCSO. And the punishment is so severe that he has to spend behind the bars not less than 10 years. This is the dichotomy now in our India regarding POCSO Act and customary marriages prevailing in various tribal sects in India. By knowing these aspects, I belongs to the district of Wayanad in Kerala state, where as per, I think Augustine is there. He is the circle inspector or DYSP or circle inspector in Pulpalli. 33% of the population belongs to tribals. There were earlier it was a majority tribal populated district. Now it has changed. Lot of cases were registering nowadays under the POCSO Act after customary marriage between the tribal peoples. That led the District Legal Service Committee, while I was working as Secretary District Legal Services Authority, Wayanad, we produced a film in the name of Incha. It is a story of one tribal couple who married prior to the age of majority as per laws. When Inja gets pregnant and got delivered to a child, her husband Vallan was sent to jail. After 7 years, he coming back and says, now I know the stringency of law. It is above all our customs prevailing in our community. And I will say this message to all my fellow members. Thereafter, a new lovers, grooming lovers, love making, a scene of love making, and the girl says, I'm ready to marry you when police will not catch us. That is the message in that film, and that film was in the local tribal language of Wayanad district, and it is available in YouTube. You can see that, and English translation is available in that film. And by this, I am concluding. My time is 10 minutes. I have taken 10 minutes more time allowed to me. By this, I am concluding that there is a dichotomy in our legal system with respect to POCSO laws and customary laws prevailing in tribal communities with respect to their marriage. You have to identify it, and I think the solution is only by a amendment in POCSO law or by a particular enactment by the Parliament of our country. In fact, I have taken up this matter to various MPs who knows me. When I visited Delhi, I went to see the External Affairs Minister and I told this issue to him, and he requested for a report from me. I know that all the legislatures know this legal dilemma prevailing in our country, but once we made an amendment with respect to scheduled tribes or scheduled caste only, it will be applicable to other communities also. We cannot make an unreasonable classification under the provisions of Constitution. So if a benefit is given to a particular community, it will become an unreasonable classification. Because of that reason, this dilemma is still pending, still prevailing. I do not know how long it will continue and how long this tribal people will be under trouble by getting married as per their customary law. By these words, let me conclude. I thank all the audience for a patient hearing. Thank you very much.
So thank you for your wonderful information. Now I am opening my platform for all the participants to come up with their questions. I request everyone, if there is any question, please come up with this. So before anyone asks, I just want to put a one question that someone has asked, that please indicate some example to indicate the effectiveness of POCSO Act. Please elaborate some example to indicate the effectiveness of POCSO Act.
Madam, what is POCSO Act? Protection of Children from Sexual Offences Act. It was implemented, it was enacted in the year 2012. Let me ask you one thing, whether prior to 2012, there were no sexual assaults against children? Of course, there were n number of cases of sexual assaults against children. Those all cases were dealt under the provisions of Indian Penal Code earlier. After implementation of POCSO Act, in the light of the UN General Assembly Convention, sexual offences against children made us very serious offences under the POCSO Act, and a clause under section 19 was enacted for that non-reporting of the same is a offence under the Act. Because of that reason, so many persons are now afraid of hiding this fact from the legal authorities. As per statute or statutory authorities, or because of a deterrence that they will be punished for non-reporter, they are forced to report it. Otherwise, by considering our social setup in our country, all the persons are trying to conceal these offences, because by considering the future of the child, by considering the reputation of the family in the society, by considering the legal battle or the difficulties to be faced while going for a legal battle, they are trying to conceal it. But now people are afraid. Even I am ready to face the troubles of legal battle. Even then I am ready to report it. So reportings are in a higher end now. Cases are reporting much. That is the impact of implementation of POCSO Act.
Okay, sir, there is one more interesting question, that if uniform civil code get applicable in our country, then how this customary practices can be tackled?
The Uniform Civil Code means a single code for all the citizens in India. In the seminar, I told you, we have codified our Hindu laws. Before 1956, there were no codified Hindu laws. All the Hindu laws were separate. Sikhs, Parsis, Jains, Veerashaivas. Every separate religion, they have got their own laws and customs. We codified it in the year 1956. But in that codification also, scheduled caste and scheduled tribes people are excluded. They were not included. If a uniform civil code pertaining to marriage is brought into enactment or brought into our land, how we can make this code applicable to the tribes? Because they are not adapted, they are not effectively studies the laws prevailing in our country. Again, that will be a dilemma or socio-legal problem in our country. Let us see how the wisdom of our legislatures will tackle this issue while implementing, or if it comes in the future.
Okay, sir, there is one more question. With this disparity in legal age of marriage, do you see child trafficking will take a new mode or method?
I'm not commenting about child trafficking, but I will obviously talk about the changes in our society at large. See, age for marriage for a girl is 18 and boy is 21. Studies says that by the age of 9 to 11, the hormones changes in the child develops. They starts producing estrogen and other hormones which provokes their sexual feelings. By the age increases, their curiosity and anxiety regarding sexual acts increases. That ultimately come to love affairs, alliances, and other usual natural feelings of the children. By the development of social media and communication system, unlike in erstwhile years, they have a lot of opportunities, platforms to communicate each other, and they will mingle freely. Ultimately, this will sometimes end in some sexual activities by the children. If it is reported, what will be the result? You can see one thing. Most of the adolescent crimes, most of the crimes reporting pertaining to adolescents. Adolescents means in between 16 to 18 age category. Maybe out of love affairs and love feelings shared between the parties. Even then, POCSO did not make them scot-free. The enactment brings those persons to the clutches of law and punishing them. That is also another social stigma in our country. That is why in 2019, an amendment came in POCSO Act. Penetrative sexual assault on a girl below the age of 16 years made more punishable, not less than 20 years. But age between 16 to 19, offense is punishable under not less than 10 years. The Supreme Court says, the Supreme Court considered this aspect in some cases, whether the girl has mental maturity to give consent. That's why I told you consent will deal with another session. Whether they have got mental maturity to give consent. But under the provisions of law, it is presumed that a girl below the age of 18 is not capable of giving consent for sex. That is also a social stigma we have to face, police officers have to face.
Sir, good evening, sir.
Good evening, Augustine.
Sir, first of all, I apologize, sir. I could not attend the meeting in time. Hello, sir.
Okay, Augustine. Okay, Augustine.
Sir, I have a small issue. I have registered a case under Section POCSO Act. It was a tribal case. The girl was only 17 years and she was pregnant for 2 months. Doctor informed us and we registered a case. In that case, she was, sorry, the husband was the only caretaker of that girl. So after the discussion with the higher ups, we decided not to arrest that person under custody and conducted medical test. After that, we released that person, not arrested and remanded. Sir, is there any legal issues in such a case? Because we did not arrest him. That was my doubt.
Augustine is a deputy superintendent of police in my jurisdiction, coming under my jurisdiction. And this problem is not the sole problem prevailing in Wayanad district. There was a lot of such issues, a lot of such cases registered by the police. But police is magnanimous enough that not to arrest, because he is not a culprit. He was customarily married his wife. After marriage, he got the right to have communion, society with his wife, and wife became pregnant. The question posed by Mr. Augustine that he was not arrested, I, being a judge, will not comment on that.
Okay.
In such cases, we took up the matter to Honorable High Court of Kerala for getting anticipatory bail. By showing the provisions under the POCSO Act, Honorable High Court rejected that bail application. Subsequently, we took up the matter. The police has filed an absconding report that they could not arrest the accused, and charge sheet investigation is over, and they filed an absconding report before the court. After filing charge sheet, we took up the matter to the Honorable High Court for quashing the same under the provisions of Section 482 of the Criminal Procedure Code. Then also, Honorable High Court says, wife become pregnant. Ask the investigation authority to arrest the accused or bring him before the laws, before law. And the Honorable High Court was not ready to quash the FIR or the charge sheet. So not arrested means not arrested whether any irregularity is there is a depth legal issue to be discussed. I think this platform is not sufficient to discuss that issue. Thank you, Augustine, for joining this meeting.
Okay, thank you, sir.
So there is one more question. I know there is shortage of time, but sorry, all the participants, this is the last question from our side because we have a limited time. Sir, the question is, as you say, if the tribal community is excluded from the scope of the law by amending the Child Marriage Act, will it affect the higher education and good life of the children from the said community?
Strictly speaking, that will not, because that enactment is purely pertaining to the marriage of the pupil. That does not specify any particular religion, caste, or community. So, Child Marriage Prohibition Act is applicable to scheduled tribe and scheduled caste also. My point is not that. Child Marriage Prohibition Act is at least there from 1930s or 1950s or 60s. They were getting married. They were going for marriage, and there were no issues that much like POCSO cases, because there was no provision in Child Marriage Prohibition Act like Section 19 in POCSO Act, non-reporter. That was not there in that act. So if any person came to know about a child marriage, he is not bound to report the same as provided under Section 19 in the POCSO Act. So that practice was going on, and they were doing the same for these long periods. Only when the POCSO Act came, the scenario changed.
Yes, sir. Thank you for your wonderful information. And now I wholeheartedly thanks our Honorable Lordship for sparing valuable time from his busiest schedule and for giving us valuable knowledge and information. Sir, we got an opportunity to hear your thoughts, and this will surely be going to help us in our respective field in one or the other way. Last not the least, I would also like to thank our Executive Director, sir, for encouraging me to conduct this session, and to all the respected board members who are present over here, and to all the participants that had graced our program with their presence. Now, because of the shortage of time, we are binding this program, but with a promise that we will come back soon with any other new topic and interesting topic covered under the law. Till then, take care, everyone, and thanks once again. Thank you so much, sir.
Thank you. Thank you very much.
Thank you, sir.
Thank you.
Thank you, sir.